Donald Trump's Attorney General Pam Bondi just spanked the American Bar Association, which is fantastic because they are terrible on the Second Amendment. You're not going to want to miss this great news out of the Trump administration and Attorney General Pam Bondi. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, so this is great news, great news. Attorney General Pam Bondi has just announced that the American Bar Association, the largest bar association in America, consisting of the greatest number of attorneys, will no longer have any special treatment or be given any special privileges when it comes to the nomination of, the vetting of, the approval of, the sign-off of federal judges, including Supreme Court justices. This is a big deal, folks, because as you know, the American Bar Association is basically a down-the-line lefty organization in terms of the causes they support. And we'll get to that in one moment. But what's very exciting is that historically the American Bar Association has played some role, sometimes bigger, sometimes less so, a role in picking federal judges by advising the President of the United States who should be picked, who's qualified, who's unqualified, and the like. Well, I'm happy to report this breaking news that Attorney General Pam Bondi has just announced that the American Bar Association will no longer receive any special treatment at all, any special privileges. In fact, they will basically be on par with, if not below, in my view, let's say, the Four Boxes Diner. And that's exactly where they should be, on par with, or maybe even below, the Four Boxes Diner when it comes to American law and American life. But with that said, let's turn first of all to the letter that Attorney General Pam Bondi wrote to the ABA announcing this a new announcement, and then we're going to talk about why it's appropriate, in my view. First of all, here is the letter that Attorney General Pam Bondi wrote to the ABA saying, "No more, folks, are you going to have special privileges. For several decades, the American Bar Association has received special treatment and enjoyed special access to judicial nominees. In some administrations, the ABA received notice of nominees before a nomination was announced to the public. Some administrations would even decide whether to nominate an individual based on a rating assigned by the ABA. Unfortunately, the ABA no longer functions as a fair arbiter of nominees' qualifications, and its ratings invariably and demonstrably favor nominees put forth by Democratic administrations. The ABA's steadfast refusal to fix the bias in its ratings process, despite criticism from Congress, the administration, and the Academy, is disquieting. Accordingly, while the ABA is free to comment on judicial nominations along with other activist organizations, there is no justification for treating the ABA differently from such other activist organizations, and the Department of Justice will not do so. Specifically, the Office of Legal Policy will no longer direct nominees to provide waivers allowing the ABA access to non-public information, including bar records. Nominees will also not respond to questionnaires prepared by the ABA and will not sit for interviews with the ABA. Sincerely, Pam Bondi, Attorney General of the United States." Bingo! That's exactly right. That is exactly the position that Attorney General Pam Bondi and the Trump administration should take vis-a-vis the American Bar Association. Now, just to show you how problematic the ABA has become, one of our favorite judges on this channel, and I think one of your favorite judges too, is Judge Lawrence Van Dyke, a Harvard Law grad out of, obviously out of the Ninth Circuit Court of Appeals. You're quite familiar with the excellent work of Judge Lawrence Van Dyke. In fact, there's no doubt he is on the list of people to be considered to sit on the U.S. Supreme Court should a vacancy arise. Now, Judge Van Dyke was rated, I believe, not qualified. Hear what I just said? Not qualified. Not qualified or maybe average or just the okie dokie. No, the ABA rated Lawrence Van Dyke's nomination to the federal bench as not qualified. That's right. That's how bad the AB is. Likewise, Judge Catherine Mizell, who you might be familiar with because she's a former Clarence Thomas clerk. We've talked about her on this channel before as well. She's also a potential Supreme Court pick for Donald Trump. She is the one that did two critical decisions. She is maybe the first judge in American history. I think she is the first judge in American history to find that a post office is not a sensitive place under NYSERPA versus BRUEN, and she does a great job analyzing the Second Amendment in all respects. That's Judge Mizell, a district court judge down there in the state of Florida. She's also issued, as I recall, a very powerful decision that basically said that the mask mandates and some of that other COVID nonsense was unconstitutional and was no-go. Again, a very powerful jurist right out of Clarence Thomas's chambers back in the day. And Judge Mizell, despite having all those fancy credentials, including a Supreme Court clerkship, was rated, again, not qualified by the ABA in the same way that, among others, Lawrence Van Dyke was. In fact, as I want to go back in time, I haven't checked this because it's so ancient history, but as I recall, the ABA concluded that Judge Robert Bork was not qualified as well, and Judge Robert Bork had some spectacular legal credentials. Nevertheless, that was what the ABA said. That's going all the way back, really, of course, to the 1980s. So with that said, in terms of the Second Amendment, the ABA has taken terrible positions. They were on the wrong side in both the Heller case in 2008, arguing that the Second Amendment doesn't protect a individual right, that basically that the lower court decision that ruled in favor of the Second Amendment, that was a decision by a three-judge panel written by Judge Lawrence Silverman, my former law professor at NYU Law, by the way. That powerful pro-Second Amendment decision by the D.C. Court of Appeals, it was the ABA that came in with an amicus brief in the U.S. Supreme Court in the Heller case, arguing that that decision by the lower court should be overturned. Happily, though, Justice Scalia wrote the decision the right way and affirmed Judge Silverman's decision in favor of the Second Amendment. Likewise, in NYSERPA versus BRUEN, the ABA submitted an amicus brief also against the Second Amendment, arguing that may issue permanent regimes when it comes to concealed carry is the proper way to interpret the Second Amendment and is the proper way from a public safety point of view. In fact, here's just a couple excerpts from the ABA brief against the Second Amendment that it submitted in NYSERPA versus BRUEN just a few years ago. Pursuant to the Supreme Court Rule 37.3, the American Bar Association, as amicus curiae, respectively submits that the decision of the Second Circuit, which was against the Second Amendment, by the way, should be affirmed consistent with the authority state and local governments have long enjoyed to fashion firearm carry regulation in light of public safety and other local considerations within constitutional constraints. That's right, folks. That's what the ABA had to say. And they go on to say specifically that may issue permitting regimes are perfectly constitutional. They basically are saying, if you think about it, right, how absurd this is, if you don't need to go to the government to say, may I pray to God? May I go to church? May I petition the government? All these things, you don't go, mother, may I, to the government. So why do you have to go, mother, may I, to the federal government, or to any government for that matter, to exercise any constitutional right, including your Second Amendment right? Nevertheless, the ABA said that's exactly the case. And obviously, it's these kinds of decisions that I think played a major role in Attorney General Pam Bondi's decision to kick the ABA to the curb, denying them any special privileges other than what any other ordinary American might have. Here's what the ABA wrote in BRUEN, just to give you a sense of how frankly, wrong they were when it comes to dealing with the Second Amendment. Based on the extensive study and the input of a wide range of participants, 10 years ago, the ABA adopted a policy on concealed carry, which urged states that allow the carrying of concealed firearms in public to adopt may-issue licensing regimes. The concealed carry policy advocates a grant of broad discretion to law enforcement authorities to determine, within defined standards and subject to judicial review, whether a permit or license should be issued. In the same vein, the ABA has opposed shall issue legislation. Hear what I just said? In the same vein, the ABA has opposed state shall issue legislation that would limit such discretion by requiring issuance of a license or permit to persons simply because they satisfy minimum requirements. So there you can see that the ABA really like the idea of may issue permitting regimes, which means that the government gets to decide who is good enough to have a gun, who is good enough to carry a gun, and who are the rest of you peons to even ask or deign to ask to carry a gun in public. Thank God the U.S. Supreme Court followed the Second Amendment and ruled in favor of the right to keep arms. and said we all have the right to carry guns in public for self-defense. But now the ABA went on to basically embrace the notion of sensitive places, which, as you know, is a euphemism for government-mandated gun-free zones. Here's what the ABA had to say to the U.S. Supreme Court in the BRUEN case in their amicus brief. In recent years, the ABA has adopted several additional policies favoring strengthened regulation of the carrying of firearms in and around certain public places, including courtrooms and courthouses, other government buildings, and polling places and election offices. So you see, folks, the ABA has been on the wrong side of the gun issue, and they've been on the wrong side of all sorts of other issues, including like the death penalty and immigration and so on. I'm not going to bore you with the details, but basically, if it involves a left-wing policy question, they basically embrace the left-wing policy question, whether it be, gay marriage or gay-related issues. It doesn't matter. They're basically toe-the-line liberals at the end of the day, and it's embarrassing that America's lawyers are like this, but that is just the way it is. But luckily for you, you get to learn from the Four Boxes Diner, and I'm not like those other lawyers. So that's good for all of us, and hopefully good for America, and good for the courts, and good for the Constitution, and most importantly, good for our right to keep and bear arms. So anyway, folks, there you have it. I think this is very good news that Attorney General Pam Bondi is making a public point to basically spank the ABA, set them off to the side, and say, you sit there in the corner and you weigh in like everybody else, but you get no special access, no special information, no special access or ability to interview anyone. You can just, comment on X like everyone else, and that's all you get ABA, even though you're the largest organization of lawyers in America. And as far as I'm concerned, thank God they've been set to the side. I totally support this move by the Attorney General Pam Bondi and, of course, by the President Donald J. Trump. So there you have it, folks. Hope you enjoyed today. Obviously, it's great to see a group of anti-gunners, a big anti-gun organization set to the side involving such a thing as helping to pick federal judges. So let's hope Donald Trump does a great job picking judges moving forward. I think he will. Fingers crossed. You can never get any of this stuff perfect because you are trying to predict the future, which is difficult to say the least. But with that said, I think Donald Trump has a great team around him. So we certainly are going to do a lot better than any of the judges that would have been picked by President Kamala Harris had we ever gotten to that world. And thank God, so far, that world has not come to pass. All right, folks, there you have it. Hope you enjoyed today's episode. Make sure you follow me at X at @4boxdiner. Don't forget to subscribe both to YouTube and to Rumble. And I look forward to talking to you again real soon here at the Four Boxes Diner.
Orders up. Table 2A.